is that why is it that the defense or the counsel of either side cannot object to a question by a senator judge? The majority leader is correct. There is no ban, there is no prohibition against any of the senators, any of the lawyers objecting to a question. But it's in the form of objection that there is a difference. You perhaps may not say, I object, Mr. Judge, but you may say, Mr. Judge, I file a reservation or an exception to that question because it tends to prejudice my client. But I think for the sake of fairness and even the perception of fairness, I think we ought to really allow any of the lawyers to make an exception rather than object verbally to a question of the judge. Because even in a grand jury, that is the procedure. In a grand jury, it's a free-for-all. You can ask almost anything under the sun without leading question, even misleading question. But the lawyers can stand up and say, we make an exception to that, so that you preserve your right to question it on appeal. Now, if what I think the good distinguished jurist is intimating and suggesting is that it will become a reversible error for mistrial, I think that's even worse, because I think we ought not to think at this stage of a mistrial, because of a procedure that will allow an appeal on every perceived reversible error, because it will prolong the political agony of this nation. If every issue, if every issue that one thinks is irreversible can be questioned on appeal. So we also appeal to the lawyers in the same spirit that our presiding president said, let us go straight to the point, wala nang paliko-liko sapagkat naghihintay ang bansa. Thank you, Mr. President.
Maraming salamat po, Ginoong Hukom. May I just, only 1 minute, Your Honor. There is a statement, with the kind permission of the Honorable Court, there is a statement on the part of the Honorable Counsel for the prosecution, Your Honor, that in the Estrada impeachment trial, the right to object cannot also be made. That is precisely why we brought this matter to the attention of this Honorable Court, because in that proceedings against the Honorable President Erap Estrada, the right to object is found, and it was only deleted under the new rules now. We wanted to know, and we are appealing to the impeachment court to merely have a re-examination. We are not imposing our will. We are appealing to the understanding and judicious management ability of this court, Your Honor, to render more justice or in consonance with the right of the accused against due process, Your Honor.
We cannot amend the rules now because to amend it will delay the proceedings. We'll have to republish it, publish the rules. But we will take this up in caucus and consider your suggestion in the light of the suggestion of a member of this court, Senator Angara.
Thank you, Your Honor.
All right, counsel for the prosecution, do you want to make any statement?
Well, Your Honor, with respect to the reference of my statement, what we said was the matter of judges asking questions to counsel and witnesses. But as to their objecting, I did not make any statement as to whether counsels can object to questions of.
Yeah, precisely. It is actually the the substance of the statement of the defense counsel, if I understood it correctly, is the tendency of questions being asked as if it is in favor of one or the other party. So I think that we will have to take up in caucus.
Thank you, Mr. President.
The gentleman from from Makati and Bicol was raising his hand.
Mr. President, he has withdrawn. And just concurred with what Senator Angara and the majority floor leader manifested, Mr. President.
All right. What is the stage of the proceeding now?
We are ready for the business for the day. We're supposed to receive documents from the PS Bank president, requested by a number of members of the Senate, an inventory of documents from the PS Bank related to the bank account of respondent, CJ Corona, which were submitted, shown and examined by the audit team of Bangko Sentral and the AMLC. The names of specific officials of Bangko Sentral and AMLC who participated in the audit and handled the bank records of the Katipunan branch and the bank account of respondent CJ Corona. Also a request by Senator Estrada for the logbook of the access, and then request of Senator Legarda to provide a technical description of their document as opposed to the annexes submitted by the prosecution, and a request of Senator Pimentel for the submission of any other available customer identification and specimen signature card in the name of Renato Coronado. Aside from that, after that, we have already discharged the witness, Mr. President. We will just await for the submission of these documents, and then we will be ready for the BPI representative.
We will give the officials of the bank concerned how many days to comply with our request. This is not an evidence for the prosecution or for anybody. It is these are documents required by the court to evaluate the supplemental request for a subpoena ducis tecum, where a document is questioned as a proper document for that purpose. And this is addressed entirely to the attention and discretion of the court. So ordered.
Mr. President, may we make a manifestation regarding... Yesterday, we were directed by this Honorable Senate to submit a memorandum regarding the nature of the testimony of the bank officials.
Not the nature of the testimony of the bank official with respect to a document that he presented to be marked and
yes,
requested by your panel to be marked as your exhibit.
Although
the witness was questioned by the defense as no longer whether he is your witness or not witness. And there was no, when the chair asked the member of your panel to state for the record whether you are adopting the witness as your witness, I think his answer was that you just wanted the document to be marked as an exhibit for the prosecution.
That is the manifestation we're going to make, Mr. President, because I was instructed by our lead prosecutor that after conference last night, the panel has decided that we will adopt the witness as our own. With respect to the evidence, the documents that he presented yesterday as to 8 accounts, Mr. President.
All right.
And that they will be marked as evidence for the prosecution.
Whatever that witness stated yesterday, you are bound by his statements.
Yes, Your Honor, Mr. President.
All the declarations, statements, admissions made by her and by him. Which one of the witnesses that were presented yesterday would you adopt as your witness?
The President who submitted the certifications as to 8 other bank accounts, Mr. President.
And how about the statement of the bank manager?
I've been instructed that it's only with respect to the President as far as the documents that they presented.
Only the statement of the President of the bank and the documents that he used as a part of his testimony.
Yes, Mr. President, respecting 8 bank accounts of the respondent, Mr.
Counsel
President.
for the defense.
If Your Honor, please, this is one of the pitfalls that I noticed in our process of trial, Your Honor, because the witness on the stand was under direct examination of the Honorable Presiding Officer and the member, senators of this court, Your Honor. Now, if this witness is now being adopted on the basis of what had been, on the questions, whether direct or cross, Your Honor, which had been propounded or made by any member of this court, and most especially the presiding officer, Your Honor, then they are relieved of the burden of undergoing introduction
all right.
to direct examination, Your Honor.
To shorten this, would you object to the adoption by the prosecution of the bank president as their witness only in relation to the document that they wanted to mark?
We are constrained to object, Your Honor. We are sorry that we cannot accommodate the prosecution on grounds of due process, Your Honor. The witness had not been examined by them. The examination was done by a member of this court and the Honorable Presiding Judge, Your Honor.
That is true. That's why
We can.
just a
I'm
minute.
sorry, Your Honor.
That is true. That's why yesterday I directed your private counsel, member of your panel, whether he was adopting the witness as his witness with respect to that document. But the witness was not his witness anymore because you finished your direct and redirect examination of that witness. He was discharged. And yet he said that he had an authority to back up his statement that they can mark the document coming from that witness who was presented for examination by a member of this court. So, did you have a backup jurisprudence on this claim?
I was told by them that they were willing to and ready to submit a memorandum, Mr. President, but after due deliberation and conference, they decided that to abbreviate the proceedings, we will just adopt the witness as far
No,
as...
you have to show us the propriety of doing what you want to be done.
Yes, Mr. President, we will abide.
Because, I cannot remember in any of my trials that could be done after you discharge your witness.
We will submit, Mr. President.
So ordered.
Okay, Mr. President, we are now ready for the continuation of the presentation of evidence by the prosecution.
Mr. President, may we call on the representative of BPI